Hello friends, welcome to Premier UPSC Ias. Let's continue with the polity lectures, uh, articles, different articles from different parts of the constitution. Okay, so we are going to cover the executive, the union part, the parliament, the legislative powers of the president, union judiciary, comptroller and auditor general of India. Okay, constitution of the union executive. The union executive constitutes of prime minister, council of ministers, attorney general of India, president and vice president. Article 79, Constitution of the Parliament. Head of the state, President, that is first citizen, Council of States, Rajya Sabha, second chamber, upper house, House of Peoples, Lok Sabha, first chamber. Indian Parliament, legislative organ of the Union government. So, a president is also a part of Indian Parliament, that is legislative organ of the Union government. Okay. Article 80, Composition of Rajya Sabha. Total strength members represent the states. 234, filled 229, elected by the elected members of state legislative assemblies, system of proportional representation by means of single transferable vote allocation on the basis of population. Members representing the UTs, total number of 4, filled are also 4, indirectly elected by members of an electoral college, system of proportional representation by means of single transferable vote. Only 2, Delhi and Puducherry. Members nominated by the president, 12, filled are also 12, from people who have special knowledge or practical experience in art, literature, science, and social service. Article 83, Duration of Rajya Sabha. The Rajya Sabha, first constituted in 1952, is a continuing chamber, that is, it is a permanent body and not subject to dissolution. However, one-third of its members retire every second year. The retiring members are eligible for re-election and re-nomination any number of times. The constitution has not fixed the term of office of members of the Rajya Sabha and left it to the parliament. Accordingly, the Parliament in the Representation of the People Act 1951 provided that the term of office of a member of the Rajya Sabha shall be 6 years. Article 81, Composition of Lok Sabha. Members representing the states 530, filled are also 530, directly elected by the people from the territorial constituencies in the states based on the principle of universal adult franchise. Members representing the UTs 20, filled 13, Parliament to prescribe the manner of choosing the members, UTs direct election to the House of the People, Act 1965, chosen by direct election. Anglo-Indian nominated by the president, 2, and filled by 2 if the community is not adequately represented, has been extended till 2020 by 95th Amendment Act 2009. Article 83, Duration of Lok Sabha. Unlike the Rajya Sabha, the Lok Sabha is not a continuing chamber. Its normal term is 5 years from the date of its first meeting after the general elections, after which it automatically dissolves. However, the president is authorized to dissolve the Lok Sabha at any time, even before the completion of 5 years, and this cannot be challenged in a court of law. Further, the term of the Lok Sabha can be extended during the period of national emergency by a law of parliament for 1 year at a time for any length of time. However, this extension cannot continue beyond a period of 6 months after the emergency has ceased to operate. Presiding officers of a parliament. Each house of parliament has its own presiding officer. Article 89. There are a chairman and a deputy chairman for the Rajya Sabha. Article 93. There are a speaker and a deputy speaker for the Lok Sabha. A panel of chairpersons for the Lok Sabha and a panel of vice chairpersons for the Rajya Sabha is also appointed. The President. Articles related to President. 52. President of India. 53. Executive power of the Union. 54. Election of President. 55. Manner of election of President. 56. Term of office of President. 57. Eligibility for re-election. 58. Qualifications for the election as President. 59. Conditions of President's office. 60. Oath or affirmation by the President. 61. Procedure for impeachment of the President. Time 62. Time of holding election to fill vacancy in the office of President. 65. Vice President to act as President or to discharge his functions. 71. Matters relating to the election of President. 72. Power of President to grant pardons, etc., and to suspend, remit, or commute sentences in certain cases. 111 assent to bills of parliament, 123 power of the president to promulgate ordinances, 143 power of president to consult supreme court, 200 assent to bill state legislature. Qualification of president. A person should fulfill the following qualifications to be eligible for election as president. He should be a citizen of India. He should have completed 35 years of age. He should be qualified for election as a member of the Lok Sabha. He should not hold any office of profit under the union government or any state government or any local authority or any other public authority. Following post under the government is not deemed to hold any office of profit and hence qualified as a presidential candidate. A sitting president, vice president of the union, the governor of any state, and a minister of the union or any state. Election of president. The president is elected not directly by the people but by members of electoral college consisting of the only elected members of union and state legislatures. 50 electors shall be proposers and 50 shall be seconders. Indirect election through proportional representation by single transferable vote by secret ballot. The constitution provides that there shall be uniformity in the scale of representation of different states as well as parity between the states as a whole and the union at the election of the president. Electoral College for President election. Lok Sabha only elected MPs. Rajya Sabha only elected MPs. Plus legislative assemblies of all states only elected MLAs. Assemblies of only two UTs, that is Delhi and Puducherry, only elected MLAs. Value of vote of an MLA and MP. Value of vote of each MLA is total population of a state by elected MLAs in assembly into 1000. Value of vote of each MP, total value of votes of all MLAs of all states by total number of elected MPs. Therefore, value of vote of an MLA is not equal to the value of vote of an MP. Value of vote of all MLAs is equal to value of vote of all MLAs. MPs. Why is chosen indirect election? The constitution makers chose the indirect election due to the following reasons. The indirect election is in harmony with the parliamentary system of government envisaged in the constitution, as the president is only a nominal executive, so it would have been anomalous to have the president elected directly by the people and not give him any real power. The direct election would have been very costly and time and energy consuming due to the vast size of the electorate. This is unwarranted, keeping in view that he is only a symbolic head. Election disputes. All doubts and disputes in relation with the election of the president are inquired into and decided by the Supreme Court, whose decision is final. The election of a person as president cannot be challenged on the ground that the electoral college was incomplete, that is, existence of any vacancy among the members of electoral college. If the election of a person as president is declared void by the Supreme Court, acts done by him before the date of such declaration or the Supreme Court are not invalidated. That is, they continue to remain in force. Oath by the President. The oath of the office to the President is administered by the Chief Justice of India and his absence the senior most judge of the Supreme Court available. In his oath, the President swears to faithfully execute the office, to preserve, protect, and defend the Constitution and the law, and to devote himself to the service and to the well-being of people of India. Term resignation and re-election. The president holds office for a term of 5 years. The president can hold office beyond his term of 5 years until his successor assumes charge. However, he can resign from his office at any time by addressing the resignation letter to the vice president. Any resignation addressed to vice president shall forthwith be communicated by him to the Speaker of the House of the People. Further, he can also be removed from the office before completion of his term by the process of impeachment. He is also eligible for re-election to that office for any number of times. Constitutional position of President. In estimating the constitutional position of the President, the particular reference has to be made to the provisions of Article 53, 74, and 75. These are Article 53. The executive power of the Union shall be vested in President and shall be exercised by him either directly or through officers subordinate to him in accordance with this Constitution. Article 74. There shall be a council of ministers with the Prime Minister at the head to aid and advise the President, who shall in the exercise of his functions act in accordance with such advice. Article 75. The council of ministers shall be collectively responsible to the Lok Sabha. Impeachment of the President. The impeachment charges can be initiated by either House of Parliament. These charges should be signed by one-fourth members of the House that framed the charges, and a 14 days notice should be given to the President. After the impeachment resolution is passed by a majority of two-thirds of total membership of that House, it is sent to the other House, which should investigate the charges and passes the resolution if satisfied. The President has the right to appear and to be represented at such investigation. Who participate in impeachment? All the members of both houses elected and nominated. In this context, the following should be noted. The nominated members of either House of Parliament can participate in the impeachment of the President, though they do not participate in his election. The elected members of the legislative assemblies of the states and union territories of Delhi and Puducherry do not participate in the impeachment of the President, though they participate in his election. All members of the parliament only. Lok Sabha, elected members plus nominated members, and Rajya Sabha, both elected members and nominated members. Powers and functions of the President. Executive powers, legislative powers, financial powers, judicial powers, diplomatic powers, military powers, emergency powers. Executive powers. All executive actions of the Government of India are formally taken in his name. He can make rules specifying the manner in which the orders and other instruments made and executed in his name shall be authenticated. He can make rules for more convenient transaction of business of the Union government and for allocation of the said business among the ministers. He appoints the Prime Minister and other ministers. They hold office during his pleasure. He appoints the following: the Attorney General of India, the Comptroller and Auditor General of India, the Chief Election Commissioner and other election commissioners, the Chairman and the members of the Union Public Service Commission, the governors of states, the Chairman and the members of the Finance Commission, and so on. He can seek any information relating to the administration of affairs of the Union and proposals for legislation from the Prime Minister. He can require the Prime Minister to submit for consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. He can appoint a commission to investigate into the conditions of SCs, STs, and other backward classes. He can appoint an interstate council to promote center-state and interstate cooperation. He directly administers the union territories through administrators appointed by him. He can declare any area as scheduled area and has powers with respect to the administration of scheduled areas and tribal areas. Legislative powers. He can summon or prorogue the parliament and dissolve the Lok Sabha. He can also summon a joint sitting of both the houses of the parliament, which is presided over by the Speaker of the Lok Sabha. He can address the parliament at the commencement of the first session, after each general election, and the first session of each year. He can send messages to the houses of parliament, whether with respect to a bill pending in the parliament or otherwise. He can appoint any member of the Lok Sabha to preside over its proceedings when the offices of both the Speaker and the Deputy Speaker fall vacant. Similarly, he can also appoint any member of the Rajya Sabha to preside over its proceedings when the offices of both the Chairman and the Deputy Chairman fall vacant. He nominates 12 members of the Rajya Sabha from amongst persons having special knowledge or practical experience in literature, science, art, and social service. He can nominate two members to the Lok Sabha from the Anglo-Indian community. He decides on questions as to disqualifications of members of the parliament in consultation with the Election Commission. His prior recommendation or permission is needed to introduce certain types of bills in the parliament. For example, a bill involving expenditure from the Consolidated Fund of India or a bill for the alteration of boundaries of states or creation of a new state. When a bill is sent to the President after it has been passed by the Parliament, he is provided with the veto powers under Article 111 of our Constitution. Under Article 200, A bill passed by a state legislature is reserved by the governor for consideration of the president, and the president has the following choices: give his assent to the bill, or withhold his assent to the bill, or direct the governor to return the bill if it is not a money bill for the consideration of the state legislature. It should be noted here that it is not obligatory for the president to give his assent even if the bill is again passed by the state legislature and sent again to him for his consideration. He can promulgate ordinances when the parliament is not in session. He can also withdraw an ordinance at any time. He lays the following reports before the Parliament: Comptroller and Auditor General (CAG), Union Public Service Commission, Finance Commission, and others. Following are the reports before the Parliament laid by President. He can make regulations for the peace, progress, and good government of the Andaman and Nicobar Islands, Lakshadweep, Dadra and Nagar Haveli, and Daman and Diu. In the case of Puducherry, also the President can legislate by making regulations, but only when the Assembly is suspended or dissolved. Financial powers. Money bills can be introduced in the Parliament only with his prior recommendation. He causes to be laid before the Parliament an annual financial statement, that is the Union budget. No demand for a grant can be made except on his recommendation. He can make advances out of the contingency fund of India to meet any unforeseen expenditure. He constitutes a finance commission after every 5 years to recommend the distribution of revenues between the center and the states. Judicial powers. He appoints the Chief Justice and the judges of Supreme Court and High Courts. He can seek advice from the Supreme Court on any question or law or fact. However, the advice tendered by the Supreme Court is not binding on the President. He can grant pardon, reprieve, respite, and remission of the punishment or suspend, remit, or commute the sentence of any person convicted of any offense. Diplomatic powers. The international treaties and agreements are negotiated and concluded on behalf of the President. However, they are subject to the approval of the Parliament. He represents India in international forums and affairs. He sends and receives diplomats like ambassadors, high commissioners, and so on. Military powers. He is the supreme commander of the Defence Force of India. In that capacity, he appoints the chiefs of the army, the navy, and the air force. He can declare war or conclude peace. Subject to the approval of the Parliament. Emergency powers. In addition to the normal powers mentioned before, the Constitution confers extraordinary powers on the President to deal with the following three types of emergencies: National Emergency, Article 352, President's Rule, Article 356, and Article 365, and Financial Emergency, Article 360. Veto powers of President. A bill passed by the Parliament can become an act only if it is receives the assent of the President. According to Article 111, when such a bill is presented to the President for his assent, he has three alternatives. He may give his assent to the bill, or he may withhold his assent to the bill, or he may return the bill for reconsideration if it is not a money bill of the Parliament. However, if the bill is passed again by the Parliament with or without amendments and again presented to the President must give his assent to the bill. Thus, the President has the veto power over the bills passed by the Parliament, that is, he can withhold his assent to the bills. The object of conferring this power on the President is twofold: to prevent hasty and inconsiderate legislation by the Parliament and to prevent a legislation which may be unconstitutional. 1. Absolute veto, withholding of assent to the bill passed by the legislature. 2. Pocket veto, taking no action on the bill passed by the legislature. 3. Suspensive veto, can be overridden by the legislature with an ordinary majority. 4. Qualified veto, not possessed by Indian President, can be overridden by the legislature with a higher majority. Absolute veto, It refers to the power of the president to withhold his assent to a bill passed by the parliament. The bill then ends and does not become an act. Usually, this veto is exercised in the following two cases. With respect to private members' bills, that is, bills introduced by any member of parliament who is not a minister, and with respect to the government bills when the cabinet resigns after the passage of bills but before the assent by the president, and the new cabinet advises the president not to give his assent to such bills. Pocket veto. In this case, the president neither ratifies nor rejects nor returns the bill but simply keeps the bill pending for an indefinite period. This power of the president not to take any action, either positive or the negative, on the bill is known as the pocket veto. The president can exercise that veto power as the constitution does not prescribe any time limit within which he has to take the decision with respect to a bill presented to him for his assent. So, in case of pocket veto, the president neither ratifies nor rejects nor returns the bill, but simply keeps the bill pending for an indefinite period. This power of the president not to take any action, either positive or negative, on the bill is known as the pocket veto. The president can exercise this veto power as the Constitution does not prescribe any time limit within which he has to take the decision with respect to a bill presented to him for his assent. President has no veto power with respect to a constitutional amendment bill, 24th Constitutional Amendment Act of 1971. Suspensive veto. President's veto over the state legislature. A bill passed by a state legislature can become an act only if it receives the assent of the governor or the president, in case the bill is reserved for the consideration of the president. According to Article 200, when a bill passed by a state legislature, it presented to the governor for his assent, he has four alternatives. He may give his assent to the bill, or he may withhold his assent to the bill, or he may return the bill, or he may reserve the bill for the consideration of the president. According to Article 201, when a bill is reserved by the governor for the consideration of the president has three alternatives. He may give his assent to the bill, or he may withhold his assent to the bill, or he may direct the governor to return the bill. If it is not a money bill for the reconsideration of the state legislature, if the bill is passed again by the state legislature with or without amendments and presented again to the president for his assent, the president is not bound to give his assent to the bill. Hence, the president can exercise pocket veto in respect of state legislation also. Powers related to ordinance. Article 123 of the Constitution empowers the President to promulgate ordinances during the recess of Parliament. These ordinances have the same force and effect as an Act of Parliament, but are in the nature of temporary laws. The ordinance making power is the most important legislative power of the President. It has been vested in him to deal with the unforeseen or urgent matters. The President can also withdraw an ordinance at any time. However, his power of ordinance making is not a discretionary power, and he can promulgate or withdraw an ordinance only on the advice of the Council of Ministers, headed by the Prime Minister. An ordinance, like any other legislation, can be retrospective. It may modify or repeal any act of Parliament or another ordinance. It can alter or amend a tax law also. However, it cannot be issued to amend the Constitution. The president can issue an ordinance even when there is no war or external aggression or armed rebellion. Limitations to the ordinance power. The exercises of this power is subject to the following four limitations. He can promulgate an ordinance only when both the houses of the parliament are not in session, or when either of the two houses of parliament is not in session, or an ordinance made when both the houses are in session is void. Thus, the power of the president to legislate by ordinance is not a parallel power of legislation. He can make an ordinance only when he is satisfied that the circumstances exist that render it necessary for him to take immediate action. In Cooper case 1970, the Supreme Court held that the president's satisfaction can be questioned in a court on the ground of malafide. The 38th Constitutional Amendment Act of 1975 made the president's satisfaction final and conclusive and beyond judicial review. But this provision was deleted by the 44th Constitutional Amendment Act of 1978. Thus, the president's satisfaction is justiciable on the ground of malafide. His ordinance-making power is coextensive as regards all matters except duration with the law-making powers of the Parliament. This has two implications. An ordinance can be issued only on those subjects on which the Parliament can make laws. An ordinance is subject to the same constitutional limitation as an Act of Parliament. Hence, an ordinance cannot abridge or take away any of the fundamental rights. Every ordinance issued by the President during the recess of the Parliament must be laid before both the houses of the Parliament when it reassembles. If the ordinance is approved by both the houses, it becomes an act. If Parliament takes no action at all, the ordinance ceases to operate on the expiry of 6 weeks from the reassembly of the Parliament. The ordinance may also cease to operate even earlier than the prescribed 6 weeks if both the houses of the Parliament pass resolutions disapproving it. This means that the maximum life an ordinance can be 6 months and 6 weeks in case of a non approval by the Parliament. Pardoning powers of the President. Article 72 of the Constitution empowers the President to grant pardons to persons who have been tried and convicted of any offense. In all cases where the punishment or sentence is by a court martial, in all cases where the punishment or sentence is for an offense against a union law, and in all cases where the sentence is a sentence of death. Pardon, commutation, remission, respite, and reprieve. Pardon removes both the sentence and the conviction and completely absolves the convict from all sentences, punishments, and disqualifications. 2. Commutation. Substitution of one form of punishment for a lighter form, a death sentence may be commuted to a rigorous imprisonment. Remission. Reducing the period of sentence without changing its character, a sentence of rigorous imprisonment for 2 years may be remitted to 1 year. Respite. Awarding a lesser sentence in place of one originally awarded due to some special fact, physical disability of a convict or the pregnancy. Reprieve, a stay of the execution of a sentence, especially that of death, for a temporary period to have time to seek pardon or commutation. The pardoning power of the president is not dependent on the judiciary. The president, while exercising this power, does not sit as a court of appeal. The object of conferring this power on the president is twofold. One, to keep the door open for correcting any judicial errors in the operation of law, and two, to afford relief from a sentence which the president regards as unduly harsh. Both the president and governor have concurrent power in respect of suspension, remission, and commutation of death sentence. Supreme Court examination over pardoning power. The Supreme Court examined the pardoning power of the President under different cases and laid down the following principles. The petitioner for mercy has no right to an oral hearing by the President. The President can examine the evidence afresh and take a view different from the view taken by the court. The power is to be exercised by the President on the advice of the Union Cabinet. The President is not bound to give reasons for his order. The President can afford relief not only from a sentence that he regards as unduly harsh but also from an evident mistake. There is no need for the Supreme Court to lay down specific guidelines for the exercise of power by the President. The exercise of power by the President is not subject to judicial review except where the presidential decision is arbitrary, irrational, malafide, or discriminatory. Where the earlier petition for mercy has been rejected by the President, stay cannot be obtained by filing another petition. Discretionary powers of the President. Though the President has no constitutional discretion, he has some situational discretion. In other words, the President can act on his discretion, that is, without the advice of the ministers, under the following situations. Appointment of Prime Minister when no party has a clear majority in the Lok Sabha, or when the Prime Minister in office dies suddenly and there is no obvious successor. Dismissal of the Council of Ministers when it cannot prove the confidence of the Lok Sabha. Dissolution of the Lok Sabha if the Council of Ministers has lost its majority. Vice President. Articles related to the Vice President. Article 63, the Vice President of India. Article 64, the Vice President to be ex officio Chairman of the Council of States. 65, the Vice President to act as President or to discharge his functions during casual vacancies in the office or during his absence. 66, election of Vice President. 67, term of office of Vice President. Article 68, time of holding election to fill vacancy in the office of Vice President and the term of office person elected to fill casual vacancy. 69, oath or affirmation by the Vice President. Article 70, discharge of President's functions in other contingencies. And Article 71, matters related to or connected with the election of the Vice President.